I'm going to be reading something from a treatise on suit and chancery by Henry Gibson. And I am here on part 3, which is maxims and principles of equity. I'll be reading this right here. 36 says, when chancery has jurisdiction for one purpose, it will take jurisdiction of all purposes. This maxim is not always so broadly stated in the reports and textbooks, but in the light of the Act of 1877 extending the common law jurisdiction of the Chancery courts, there can be no doubt about the correctness of the rule as given. Pomeroy states the rule thus: where a court of equity has obtained jurisdiction over some portion or feature of a controversy, it may, and will, in general, proceed to decide the whole issues, and to award complete relief, although the rights of the parties are strictly legal, and the final remedy granted is of the kind which might be conferred by a court of law. The reason of the rule is the duty of the courts to prevent a multiplicity of suits. The court of equity delight to do complete justice, and not by halves. Our Chancery Court acted in accordance with this rule prior to the Act of 1877, and it may now be considered as an invaluable rule, and one attended with very beneficent results. Where suits are brought to enjoin the further prosecution of a pending action at law, or the enforcement of a judgment recovered at law, either on the ground of some equitable defense not cognizable by a law courts. Cognizable means jurisdiction. Or on the grounds of some fraud, mistake, accident, or other incident of the trial at law, which render the legal judgment inequitable. In such cases, a court of equity, having obtained jurisdiction for the purpose of an injunction, will decide the whole controversy and render the final decree, even though the issues are legal in their nature and capable of being tried by a court of law, and the legal remedies therefore are adequate. This rule is general in its operation and extends to all suits brought to obtain the special relief of injunction. So injunction is a relief, it's a special relief. That's interesting to know. And is not confined to all suits. It's not confined to suits for the purposes of enjoining actions or judgments at law. It may be stated as a general proposition that wherever the Chancery Court has jurisdiction to grant, wherever the Chancery Court has jurisdiction to grant the remedy of injunction for some special purpose, even though the injunction covers only a portion of the controversy, it may go on and decide all the issues and make a final decree granting full relief in the same manner as could a court of law, decreeing damages for the wrongs enjoined when proper. Particular instances of the operation of this general rule concerning the remedy of injunction may be seen in cases of waste, of private nuisance, and of continuous or irreparable trespasses, where the Chancery courts, having obtained jurisdiction by injunction, will complete the relief and complainant is entitled to by decreeing him damages for the injuries done. If the Chancery Court obtains jurisdiction of a suit for the purpose of granting some distinctively equitable relief, such, for example, as a discovery, or the specific performance of a contract, or the rescission or cancellation of some instrument, and it appears from facts disclosed on the hearing, but not known to the complainant when he brought his suit, that the special relief prayed for has become impracticable, and the complainant is entitled to the only alternative relief possible, that of damages. The court then will, instead of compelling the complainant to incur the double expense and trouble of an action at law, retain the cause, decide all the issues involved, and decree the payment of compensatory damages. It is a fundamental rule of equity jurisprudence that the Court of Chancery, in any cause coming before it for decision, if the circumstances of the case permit, and all the parties in interest are or can be brought before it, will determine the entire controversy and award full and final relief, and thus do complete justice to all the litigants, whatever may be the amount or nature of their interest or liability, and thus to bring all possible litigation over the subject matter within the compass of one judicial determination. By virtue of this rule, and in order to promote justice, the court, having obtained jurisdiction of a controversy for one purpose, will extend its judicial cognizance over rights. Judicial cognizance means judicial jurisdiction over rights, interest, and causes of action, which are purely legal in their nature, and will award remedies which could have been adequately bestowed by a court of law. All this could have been done before the Act of 1877, and since that act, the rule herein stated has become one of the ordinary jurisdiction of the court. Very interesting. I didn't know. By reading this, I'm learning a lot. But by going to the high court and getting an injunction, it seems that is basically asking for equitable relief. That is interesting. Anyway, this is Suits and Chancery. Let's see, Suits and Chancery by Henry Gibson. You guys can find this for free on the internet. Peace and love.